Colin O'Keefe here for LXBN TV. In a case that's making headlines, the Colorado Supreme Court ruled that even though he was using it medicinally, a Dish Network employee could be fired for marijuana use. Joining me to discuss the case and its impact is attorney Michael Groebe. He's with Foley Lardner and author on their blog, Labor and Employment Law Perspectives. Michael, first off, again, even though this case is making some headlines, can you walk us through the case and the ruling just for those of us who aren't up to speed?
Sure. Brandon Coates was a plaintiff in the case, and he's a quadriplegic. And he was working at Dish Network as a telephone customer representative. And when he was been using medical marijuana to deal with the muscle spasms and to control muscle spasms. When he was subject to a random drug test by Dish Network, he tested positive and he was subsequently discharged. He decided to sue, saying that his discharge was unlawful because Colorado has a lifestyle law, or a law that's a lawful activity statute that provides protection for people engaging in lawful activity outside of work. When he sued, the trial court and the Court of Appeals ruled in favor of Dish Network, and he appealed to the Colorado Supreme Court. Colorado Supreme Court decided to hear the case back in January of 2014 and heard oral arguments in September of last year. On June 15th, the Colorado Supreme Court decided that because the definition of what it means to be lawful under the lawful activity statute means that it has to be lawful under both state and federal law, and because marijuana remains, regardless of what the use, whether it's for medicinal purposes or recreational, remains unlawful under federal law. Therefore, it was unlawful. It was unlawful activity and didn't get the protection under the Colorado lawful activity statute.
I see. So, and second, the ruling, how impactful is this going to be? And, say hypothetically, what would it take for an employee to be allowed to use marijuana medicinally? Obviously, Colorado has that lifestyle law. And then, of course, it's legal there in Colorado as well. So that's, not going to do it. What would it take for this type of thing to be protected for an employee?
The first question, how impactful is this? There's a number of states across the country that have these similar lifestyle laws. And really the laws were set up to protect people from drinking and smoking outside of work or doing things that their employers might not agree with morally or ethically or something like that, but aren't necessarily unlawful. And it was to provide them some protection. So it was a very interesting case for a lot of employers across the country, especially in states that have medicinal marijuana laws and these lifestyle laws. So it could be potentially impactful. It probably will give some comfort to employers in those states that they'll likely have the same arguments that they can make. But in order for there to be some protection for Mr. Coates or others like him in Colorado, likely one of three things would have to happen. One, there'd have to be a modification of the lawful activity statute in Colorado. They'd have to change the definition of what it means to be lawful and add some specific language that says because it's lawful under state law, then it's lawful under the lawful activity statute. That's one. Two, they could modify the actual medical marijuana law that's in Colorado to have similar language such as Delaware, Arizona, and Minnesota. In all three of those states, they have specific language that says that you can't be fired simply for testing positive unless you're under the influence, in possession, or using at work. So they could modify the law, and they'd likely have an argument there. Third, which is probably the most long shot, is that federal law could change, and marijuana could no longer be a Schedule I narcotic, which means it has no medicinal purpose. And that change, therefore, they could make an argument that if federal law changed, then it could be lawful under both state and federal law.
Absolutely. If it becomes federally legal, then you start to get into the situation where these lifestyle laws wouldn't have to be changed because they would be fine under state and federal law, similar to alcohol, of course. That makes sense. Makes sense. Once again, that was Michael Groebe of Foley Lardner. I appreciate him coming on talking about this again. Again, you can find his insight and that from his colleagues in this space at laboremploymentperspectives.com. Thank you for joining me today, Michael.
Thanks, Colin.